So a new case challenging the ATF's actions against bump stocks is up for Supreme Court consideration. So let's talk about this. How's it going, everyone? My name is Anthony Miranda. I am a licensed and practicing attorney in the state of California with an emphasis on Second Amendment rights. I've been part of Second Amendment litigation both at a state level and also at a national level, while serving as staff attorney with the Firearms Policy Coalition legal team. My goal with these videos is not to provide any legal advice, but instead to give you insight into the inner workings of the Second Amendment litigation that's currently going on at multiple levels, and also give you a greater understanding of the battle that's going on in the Second Amendment realm. As I mentioned in the intro, in this video, we're going to be discussing a new case challenging the ATF's actions and regulations on bump stocks and how they are treating them to actually be machine guns, and how a case is now up for Supreme Court consideration dealing with this very issue. The case we're going to be talking about in this video is McCutcheon v. US. In the past, we discussed some other cases that were up for Supreme Court consideration. Those cases included Apashian and the GOA case, and we've also discussed another case that is currently pending before the Fifth Circuit, which is the Cargill case. But there is still this case, this McCutcheon case, that's at the Supreme Court level, which is challenging an aspect of the ATF's actions in relation to their restrictions against bump stocks. Specifically, this case challenges the takings aspect of the ATF's new rule on bump stocks, which is relevant not just for these ATF actions specifically against bump stocks, but it also has implications and impacts on other types of actions by the ATF, like their regulation of other types of firearms and devices. And this issue is only going to grow in relevance as the ATF continues to take more actions, more regulatory actions against other items like they have against frames and receivers, that they are planning to do against pistol braces in December, and more specifically will directly impact actions like force reset triggers that they are trying to treat as actual machine guns, and also how they are treating solvent traps to be homemade suppressors. Now, some quick background on this whole issue, how it arose, and why this case is so important not just for bump stocks, but other types of ATF actions and violations as well. For many years, the ATF had correctly concluded that the NFA and GCA's definition of the term machine gun does not include devices like bump stocks. However, after the incident in Las Vegas, the ATF, after being ordered by then President Trump, decided to arbitrarily change the regulatory definition of machine gun so that bump stocks would be considered to actually be machine guns. This new rule took effect in March of 2019, and therefore under federal law, owners were required to either destroy the devices or to surrender them over to the ATF. This change in definition made possessors of bump stocks subject to punishment of 10 years in prison and or a fine of $250,000 if you fail to either destroy or to surrender those devices. In this case, the petitioners are challenging that aspect of the ATF rule, which required them to either destroy their items or to surrender them over to the ATF, and all of this was done without compensation to those individuals. In this case, petitioners are owners and sellers of bump stocks. Now, after the ATF promulgated that new rule banning the possession of bump stocks, the petitioners here complied with the rule and destroyed and surrendered all of their bump stocks. They then sought the just compensation for the taking of their private property, and that's kind of how this whole case arose. This case is a challenge to this ATF rule, and the fact that this ATF rule required individuals to destroy or to surrender their items, but they got nothing in return. The federal government did not compensate them for the taking of their property. This case then made its way up to the U.S. Federal Circuit Court of Appeals, who rejected the plaintiff's Fifth Amendment taking claims. In that decision, a majority of the panel held that there is an inherent restriction on the title to any piece of personal property in America, essentially, that is potentially subject to federal agency regulations under their delegated legislative rulemaking authority. In the simplest terms, the court here rejected the plaintiff's claims that there was an unconstitutional taking as a result of the ATF's new bump stock rule. This was because the court found your right to personal property is limited when an agency like the ATF has rulemaking authority over these types of items and devices. Therefore, one of the logical concerns from this decision is that there is this limitation on your right to possess firearms and other firearms-related items, since the ATF has regulatory authority over those items. As a result of this decision and this case has now made its way up to the Supreme Court and is seeking the Supreme Court to review this specific issue. As the petitioner stated, the Federal Circuit Court's holding raises fundamental questions about the nature of personal property in a nation in which nearly every object is subject to some sort of grant of legislative authority to an agency. By redefining the nature of title to personal property in a country dominated by grants of general regulatory authority to executive branch agencies, the Federal Circuit has removed a bedrock restraint on government power and eliminated a means of redress for citizens harmed by exercises of such power. If the Federal Circuit Court is right, then federal agencies can, with a stroke of a pen, outlaw not just the future sale, but the mere private possession of cars that burn too much gas or light bulbs deemed too inefficient, and so on without paying a dime of compensation to their owners. The Federal Circuit Court's holding thus presents questions of substantial importance that the courts below, as well as commentators in the property field, have recognized as doctrinally incoherent, and the decision conflicts with the court's prior holdings applying to takings clause to personal property. They go on to state that under the Federal Circuit Court's decision, citizens and merchants alike are left with no recourse for the forced seizure and destruction of millions of dollars worth of lawfully acquired property. In this petition, the petitioners discuss how there is a well-established history prior to the final rule where the ATF had also clearly established that bump stocks are in fact not machine guns. They state that ATF has long treated bump stocks as falling outside the statutory definition of a so-called machine gun. ATF permits gun makers to seek classification letters from ATF prior to manufacturing a gun. In 10 classification rulings between 2008 to 2017, ATF held that several bump stock devices were not machine guns. Now, one of the interesting things with this ban as well, and that is pointed out in this petition, is the fact that the ATF did not even issue a grandfathering of the bump stocks that were already in people's possession prior to this new rule, and which also were purchased under the ATF's prior guidance that these items were in fact lawful for you to purchase, possess, and sale. Here, the petitioners state that the ATF could have grandfathered in existing devices and imposed its ban on a prospective basis, but it chose a different path. A takings claims arise as a consequence. The government, by its own statement, may not transform private property into public property without compensation. So that's really what this whole case is about. It's that specific aspect of this ATF bump stock ban. It is the consequences of that new rule and how they required people to either surrender these devices or to destroy them. And this was all done even without any just compensation. And it was even done without any grandfathering. So the ATF went full bore. They kind of got away with it, and now they're likely going to plan to do it with other things. So that's why this case is so important. This case is relevant not just for bump stocks, like I said. It's also relevant for other ATF new rules and actions, like the recent actions against forced reset triggers, treating those to be machine guns, and also solvent traps. The ATF is taking similar actions against those items, with the implications that individuals will need to either potentially destroy the items that they prior were in lawful possession of, that was their prior lawful property, but now all of a sudden, just like with bump stocks, the ATF changes its mind, says that these are illegal, and you have to either destroy them or you have to surrender them. And oh, by the way, they're not going to pay you a dime for your property. So this is a case I'll definitely be keeping my eyes on. If you have any questions, go ahead and comment down below and I'll try to answer the best of my ability. You can ask questions like, so recently someone asked what my favorite burger place is. They were asking about In-N-Out or Whataburger. Personally, my opinion is I think In-N-Out is better. I've had Whataburger. I've had all the burger places. I've been to Texas multiple times. I'm from the West Coast. I'm from California, so inherently I have a bias towards In-N-Out, but let me know what you guys think down below because I know it's a debate. I just personally think In-N-Out is by far superior, but I'm curious what you guys say. So if you like this video and support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Algore's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of 2A news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation is built by armed scholars, and this nation will be maintained by armed scholars.